Yet another update on the QuadrigaCX drama. Okay, folks, most of you have been to the website. You've seen this statement. Lots of folks panicking. I'm seeing all kinds of FUD and, drama on Reddit. I'm seeing it on Twitter. I'm seeing it in my own commentary, okay? I want to explain to you, first of all, this is Canada, not the United States of America. The rules are very different. The laws are very different. Okay, you need to get your head around that. We're not American. There is no Chapter 11 here, all right? That's not what's going on here. Michael Bronx 2 hours ago posted this on Reddit, and I think it is an absolutely fantastic post, so I'm going to tell you to ignore all the others and read only this one, and I'm going to read it to you. So that everyone understands, I'll make it simple. They applied to the court for protection under the CCAA. They protect themselves from all lawsuits, which is normal. If the request is accepted, they will be protected for 30 days from any legal action from creditors, person to whom they owe money. During this protection, it is prohibited for the company to undertake procedures to uphold the creditors, but during these 30 days, the company can continue its activities, pay its employees, etc. To sum it up, all assets are frozen. Now, they don't have to close the door. They can take care of the employees. That 30-day gives them a chance to kind of restructure, which is what they've been saying when they do update us. My beef is they haven't updated us very often. I'll carry on. When applying to the court, the company must provide a statement of its assets, which is equity, and liabilities, which is its debt. Okay? So now they're going to come clean with all their books before the courts. So everybody thinking they're Mount Gox and running off to an island, I keep saying it, try and maintain a little bit of confidence. I'm only doing this. Anyway, I don't want to digress. I'm only doing this because I care about Canada and I care about the crypto space. I really don't have time, guys. I'm working 12 to 14 hours a day just keeping up with my regular client, my regular day job. I'm doing it because I actually care. I care about the crypto space and I care about my country, and I don't want crypto getting a black eye. So the purpose of this procedure is to allow the company to find a plan of transaction to either reimburse amounts to its creditors or a plan or arrangement to reorganize the company's business. I know there's a bunch of you watching go, well, I got to get in line. Feel free, but there's nothing you can do. If they lock it for 30 days, you cannot sue, okay? I think they're going to follow up with what they're saying, which is they're going to reorganize the company's business, but we're going to have to see. Time's going to tell. I guess we'll know in about 35 days, won't we? If the court that will manage the situation and monitor the good, it is the court that will manage the situation and monitor the goodwill of the company, so don't worry. Okay. Now the courts are basically going to they're not going to poke in. They're going to take over the books. Okay. Generally, the debtor company, a company that owes money, begins negotiations with its creditors and other stakeholders immediately after the initial order is issued. The request to be placed under CCAA protection. The court shall establish the procedure for the examination and approval of claims submitted by its creditors. He or she may appoint an agent who will be in charge of handling complaints. They need that. They need a court-appointed agent that's giving us updates on a regular basis and is acting as the mediator, okay, or handling the complaints department. The role of the controller includes informing creditors about the claims procedure, providing them with proof of claims forms, and explaining how to complete and file them. This is not Chapter 11 like in the States. Don't get confused. It's Canada, not the United States. Important, the controller will provide periodic updates on the progress of the procedure and will inform stakeholders of any significant developments. The comptroller is required to publish certain documents on its website, such as the comptroller's reports and court orders. He can also answer your questions about the procedures. So stop reading the FUD, stop speculating. This is what we need. We need it in the hands of the courts. And if they truly are restructuring and trying to stay afloat, which I really sincerely hope they are, this is the only way they're going to be able to do it. And judging by what I've seen on Reddit in the last, month, they needed to do this. Very important. Creditors have a duty to prove their claims. Well, most of you either used a Visa or you have statements, right? You have bank statements. You have lots of proof. I mean, just go through your statements alone. Unless you were like putting them in for a FlexiPin or something, then you probably have the receipts from that, correct? Okay, so once the parties have negotiated the proposed plan, the debtor company or a creditor will ask the court to convene a meeting of creditors to formally vote on the plan. If the plan is accepted, creditors will be repaid or processed in accordance with the terms of the plan. If the plan is rejected, they no longer have protection against lawsuits by creditors. At that point, you can sue. Okay. Important. As long as the request has not been accepted, you can take legal action. So you could jump on a lawsuit right now. And if they're denied by the court, then of course you can. But what if it really is real? What if they really are restructuring? And that was the big deal about this whole thing. And they really don't have the keys. Yeah, they're trying to sort things out. Now, I know we've seen some reasons to believe, but like, again, it's all speculation. I love that it's going into the hands of the court. In fact, if anything, I think that takes a lot of the panic out of it, but then that's just my opinion. Okay. I'm seeing, opinions are like, anyway. I think there's just too much FUD surrounding it. So I'm thankful that the court's involved, okay? And in 35 days, we'll have an answer. But at this point, they haven't moved off to an island with the guy from Mount Gox, and I really like that. And if they were trying to be crooked about it, do you really think they'd bring it before the courts? I don't think so. The courts are going to look at all those assets, are going to look at all those liabilities, and you know what? I see even on Reddit, there's guys going to the effort to try to trace wallets and second guess whether or not this is their wallet. And kudos to you for having enough time to do that. Me, I work 14 to 16-hour days on a typical basis, just keeping up with my client stuff, because unfortunately I'm not rich enough. I have to still work for a living, as many of you do. So please understand that I'm not a news reporter. I'm a crypto mining channel, and I get tired of the fact that I'm seeing so many channels on YouTube, monetized ones, with guys that sit at home or sit in their parents' basement and report FUD all day long. Every little tidbit of news comes off the internet. Crypto going to $10 million. Yeah, whatever. I wish YouTube would eliminate that. But from my stance, I'm already being trolled enough that I thought about walking away from it. But I know there's a lot of you people out there need help. And as I said, as a Canadian, as a tech, and as an advocate of cryptocurrency, I plan to keep my finger on the pulse of this thing. So let's not panic. Next week they should be registered with the courts, or let's hope so, and that the court makes this decision correctly. And I have a lot of faith in the fact they will. So in the meantime, I also want to mention one more thing. I see a bunch of you saying, hey, contact such and such at Gmail. Let's get a lawsuit going. You know what? I've been a network guy for like 35 plus years. I spent years teaching for Intel network design and security, as well as other companies. I've contracted out to all kinds of companies. I used to travel all over North America teaching high-end tech guys. And Gmail guys, it's like you might as well put a banner on the street. It is like, anything that's free is not free. You are the product, and there is no security. So don't use Gmail. If I work for a number of lawyers' offices, we have secure mail on their own servers using SSL, secure socket layer certificates. Don't use Gmail for communicating, if anything. Look up what happened with the Chinese government years ago. They hacked Gmail. Anyway, I don't want to digress on that, but personally, guys, yeah, remember, if it's free on the internet, you are the product, and there is nothing free. Anyway, thanks for tuning in. I hope this helps some of you sleep better tonight or tomorrow night or whenever you watch this. But I would say that overall, this court thing is a good thing. I'll put this article in the commentary so you guys can follow up on it. And sorry for a little bit of a rant, but I got to tell you, if I've learned nothing else, I've learned not to do news stuff. Because, man, is it ever stressful. Unless I was just reading everything I saw on the internet like a lot of pages do. Anyway, thanks for tuning in. Sorry I ranted on. Dave Tech out.